On the night of March 29, 1991, Rachael Johnson, a 23-year-old single mother, stepped out of her car with a flat tire in a nearly empty parking lot near the intersection of Dan Street and Glenwood Avenue in Akron, Ohio, and walked into the darkness to find someone who could help her, and she never came back. The next morning, her body was found on Weller Avenue, sexually assaulted, stabbed multiple times, and partially burned, but the person who did all of that left behind nothing except a DNA sample that the technology of 1991 had no way to read. Her daughter, Caitlin, 3 years old at the time, grew up without her mother and without many memories of her, but she has countless memories of the neighbor who lived directly across the street, the man who gave her her first motorcycle ride, attended her family birthday parties, and bought lunch for her aunt every day on the way to work for many years. Akron police searched the city for the killer while he sat at the dinner table with the victim's family, and the DNA sample sat silently in the evidence locker for 28 years. This is the story of the woman who walked into the night and never returned, of the murderer who hid in plain sight for nearly 3 decades, and of the DNA sample that waited long enough to finally name him. And every single detail you are about to hear has been verified through court records, police investigation reports, autopsy results, and prosecutorial documents released in court. Before we dive deep into this shocking story, please let us know where you are watching from, and if you like this video, don't forget to subscribe to the channel and turn on notifications. Akron, Ohio, at the end of March 1991, operated at the characteristic pace of an industrial Rust Belt city where rubber and polymer factories had once put the city on America's economic map, but by the early 1990s had begun to shrink, leaving behind quiet working-class neighborhoods stretching along the roads connecting Akron and Tallmadge, with sparse streetlights and commercial parking lots that were almost completely deserted at night. Rachael Johnson, 23 years old, a single mother, lived in the area with her 3-year-old daughter, Caitlin. Her father, Larry Johnson Sr., and stepmother June Johnson lived nearby and frequently helped watch their granddaughter so Rachael could go to work or meet friends in the evening. On the night of March 29, Rachael left home after Caitlin was being cared for by relatives and went out with a friend. It was an ordinary evening with no special plans, no unusual events, and no recorded conflicts with anyone. When the night grew late, the two headed back. The car got a flat tire midway, forcing them to pull into a parking lot near the intersection of Dan Street and Glenwood Avenue, an area that served as a transition between rows of residential houses and a few small shops. During the day there was foot traffic, but after 10 p.m., the area was almost completely dark with little activity. Rachael got out of the car and walked into the night to find someone who could help. That was the last action her friend confirmed. The image of Rachael stepping out of the car, turning her back, and walking along the side road, gradually disappearing into the darkness. From that moment on, no witnesses saw her, and no calls were made from any public phone or any other means of communication that were recorded. In 1991, Akron did not yet have widespread street security cameras, no cell phones to record locations, and no GPS or cell tower data to track movement. The entire ability to trace a person walking alone at night depended completely on whether someone happened to see her, and that night, no one did. On the morning of March 30, a passerby discovered the body of a young woman lying in the 700 block of Weller Avenue in Akron's Chapel Hill neighborhood, not far from where the car had broken down. The person immediately called the police, and the Akron Police Department arrived at the scene within minutes. When the first patrol unit from the Akron Police Department reached the 700 block of Weller Avenue, they did not need the initial classification process to understand the serious nature of the case. He nearly lunged toward the defendant and had to be held back, his voice rising not like a prepared statement, but like the shout of a man who had stayed silent for too long. "Don't look at me, you son of a bitch." When he was held back and tried to continue speaking within the framework of the court, he choked up, paused, and could not finish everything he intended to say, and what he did say carried the voice of a man who was so exhausted that he no longer had the strength for constant anger, but also never had the strength to let go. "It never ends. They say closure. What the hell is closure? I ask the court to give him what he deserves. I want to see him in prison for the rest of his life." After him, Caitlin Rocks, Rachael's daughter, stood up, and she faced Daniel Rees in a way she had probably imagined in her head thousands of times since learning his identity, but no imagination could have prepared her enough for the actual moment of standing in front of the man who had killed her mother, The man she had once called by name, once ridden behind on a motorcycle, once considered a harmless neighbor. She looked straight at Rees and said, "Look at me when I'm talking to you, Dan." Then she asked the questions she knew would never have satisfactory answers, but still needed to be asked because they were all she had. Why were you right across the street from my house? Why did you steal my life? Was it guilt? What was it? I don't understand. I knew you, but I didn't know my mother. The final sentence, "I knew you, but I didn't know my mother," remained in the courtroom like something that could not be erased, because it summarized in 6 words the entire injustice Caitlin had lived with for 32 years. She had memories of her mother's killer, but she had no memories of her own mother. Daniel Rees sat and listened to those statements and at times tried to hold back tears, though no one in the courtroom could know whether those tears came from genuine remorse, from fear of the impending sentence, or from something else that only he knew. When it was his turn to speak, he said, "Everything these people are saying is true. I am a monster. What I did was horrible." He apologized to the Johnson family not only for the murder, but also for befriending them in the years that followed, and he called his insertion into the victim's family life, attending birthday parties, giving Rachel's daughter rides, buying lunch for her sister, the worst thing of everything he had caused, a remark that, when placed next to the level of violence on the night of March 29, 1991, might cause many people to argue about the order of terribleness, but it showed that even Rees recognized, or wanted to appear to recognize, that there was a form of cruelty that stretched across decades without needing physical violence. Judge Susan Baker Ross pronounced the sentence, life in prison, with the earliest possibility of parole after 30 years, meaning Rees would have to wait until he was 90 years old before he could first stand before a parole board, and even then, whether he would be granted parole was an entirely separate decision. This was the harshest sentence Ohio law allowed at the time the crime occurred in 1991, except for the death penalty, a sentence that had been taken off the table by the plea agreement. Gorman, the defense attorney, did not object to the sentence and only said briefly, "This is a life sentence." He understood that when he walked in here. When looking back at the entire journey of Rachael Johnson's case from the night of March 29, 1991, to the sentencing hearing on July 28, 2023, the question that anyone following the case would ask is not why the case was solved, but why it remained deadlocked for nearly 30 years when the most important evidence had been sitting in the evidence locker from the very first day. The answer does not lie in shortcomings in the investigation, does not lie in procedural mistakes or missed leads, but in a simple and cruel reality. The technology needed to decode that evidence did not exist at the time the crime occurred and would not exist for nearly the next 3 decades. In 1991, CODIS had not yet been implemented, meaning the DNA sample collected from the victim's body had no system to match it on a national scale. Even when CODIS officially became operational in 1998, it could not help this case, because Daniel Rees had no criminal record. He had never been arrested, never been convicted, never had to provide a DNA sample to any agency, and therefore his biological profile simply did not exist in any criminal database in the entire United States. He was a blank space in the system, a person who, in terms of data, had never committed a crime, and therefore no tool before 2018 could reach him. In addition, Akron in 1991 did not have widespread street security cameras, no cell phone location data, no GPS, and no form of digital trace that could help track the victims or the killer's movements on the night of the crime. The entire investigation depended on traditional methods: witnesses, crime scene examination, interviews, and all of those methods had been carried out, but did not lead to Rees because he had left no trace in anyone's memory, did not appear in any witness statements, and lived in a way that made him invisible even to those closest to him, including the victim's own family. The case was solved not because someone found a missed lead, but because an entirely new technology was born and changed the rules of the game from the ground up. Forensic genetic genealogy, the method that uses public genetic databases to identify distant relatives of a suspect, then builds a reverse family tree and narrows it down to a specific individual, did not exist in any form in 1991, did not exist in 2000, did not exist in 2010, and only became a criminal investigative tool from 2018 after the Golden State Killer case. In other words, the gap between the day the crime occurred and the day the necessary technology to solve it was born was 27 years. And throughout those 27 years, no human effort, no matter how persistent or skilled, could overcome that barrier. But there was one factor without which even genetic genealogy would have been useless: the decision to preserve the DNA sample from 1991 according to long-term biological standards. That was a procedural decision made by technicians and investigators whose names would never appear in the news. People who could not foresee that the biological sample they were sealing would sit in storage for nearly 30 years before being opened again. But if that sample had been destroyed in any evidence room cleanup, if it had been stored improperly and degraded to the point where it could not be analyzed, if it had been lost in any file transfer between units throughout nearly 3 decades, then AdvanceDNA would have had nothing to upload to the genealogy database, the police would have had nothing to match against the sample from Rees's trash, and Daniel Rees would have lived out the rest of his life as an ordinary man in Barberton, Ohio, never named by anyone, never stepping into a courtroom, never having to look into the eyes of the daughter of the woman he had killed and hear her ask why. A collaboration between the Akron Police Department, the Ohio Bureau of Criminal Investigation, and AdvanceDNA in Texas is proof that solving cold cases in today's era is no longer the work of a single agency, but requires connections between local agencies, state agencies, and the private sector, each contributing a part that the other does not have. From evidence records to genetic analysis capabilities to legal authority, Rachael Johnson's case, when placed alongside hundreds of other cold cases that have been solved thanks to genetic genealogy since 2018, shows a lesson that the U.S. justice system is gradually internalizing. Preserving biological evidence is not an administrative procedure, it is an act of keeping the opportunity for justice in the future, a future that at the time of storage no one knew what it would look like, but that can now be affirmed to exist. Genetic genealogy is changing the landscape of cold cases across America, turning files that were once considered completely static, no progress, no movement, no new direction, into cases that can be solved in just a few months if the biological sample remains intact. And the final, most frightening lesson comes from Daniel Rees himself. A killer can hide right in the community, can live next to the victim's family, can give the daughter of the woman he killed motorcycle rides, and buy lunch for her sister for many years. But DNA does not lie, does not disguise itself, and does not care how well he hid or how long he waited, because it only needs to be asked the right question with the right technology. And when that happens, nearly 30 years of hiding collapse in a single laboratory result. Rachael Johnson was murdered on the night of March 29, 1991, when she was 23 years old, when her daughter was only 3 years old, when she was just trying to find someone to help her on a dark road in Akron, Ohio. The perpetrator was arrested on March 11, 2020, nearly 29 years later. He was sentenced on July 28, 2023, more than 32 years later. Throughout the long stretch of time between those 2 points on the timeline, the man who killed her did not run, did not disappear, did not live the life of a fugitive in some distant city. He lived directly across the street from her family's house, gave her daughter motorcycle rides, attended her family's birthday parties, bought lunch for her sister every day on the way to work, and not a single one of them knew that the person sitting with them was the one who had put an end to Rachael's life on that dark night in March 30 years earlier. But throughout that time, there was one thing that did not disappear. The DNA sample collected from Rachael's body on the morning she was found, sealed and preserved in the Akron Police Department's evidence locker, sitting there in silence for nearly 30 years, waiting for the day science advanced enough to ask it the right question. And when that day came, it answered. Justice may come after 32 years, but it still comes. And sometimes, the smallest things. A biological sample carefully preserved by technicians whose names no one remembers, a genealogy database where the people who submitted samples never thought their DNA would help solve a murder case, are what change everything. Thank you for following the entire journey of Rachael Johnson's case. Don't forget to subscribe to the channel and hit the notification bell so you don't miss the next stories, where we continue to explore cases revealed through justice and modern forensic science. See you in the next video. Rachael Johnson's body lay on the road in the Chapel Hill residential area, a neighborhood where on normal mornings people would walk their dogs along the narrow sidewalks, push trash cans to the curb, and wave to each other over low fences between the quiet single-story houses lined up on both sides of the street. But that morning, that familiar road carried an image that any resident who accidentally saw it would carry with them for the rest of their lives. The victim was left right in the middle of the street, not in the bushes, not inside a car, not in a hidden corner where the killer tried to conceal her, but right in the everyday living space of the neighborhood, as if the person who committed the act did not care who would see it, or simply did not have enough time left in the night to think about it. The body showed that Rachael had been sexually assaulted, stabbed multiple times, and partially burned. Her body was naked from the waist down. Every detail at the scene, from the position of the body on the road to the spreading burn marks on the asphalt, to the condition of the torn and pulled down clothing, told the same story, that this 23-year-old woman, who just hours earlier had stepped out of her car to find help on the deserted road near Dan Street, had encountered a level of violence completely disproportionate to anything she could have imagined when she set foot on that dark sidewalk that night. The Akron Police Department cordoned off the entire area of Weller Avenue within several hundred meters around the body's location and established a crime scene perimeter according to homicide processing procedures. The forensics team was called in and began documenting with photographs and position diagrams, marking every physical detail within the scene, the distance from the body to the entrances and exits of the neighborhood, burn marks on the ground, and any personal items left behind. The surrounding area was searched for the murder weapon, shoe prints, tire marks, fabric samples, or anything that might indicate the killer's direction of approach and departure. But the hard asphalt road was not an environment that preserved footprints. The night wind had had many hours to disperse any small fibers that might have clung to the surface, and the partial burning of the body had destroyed many direct contact traces between the killer and the victim, as if the very purpose of the fire was to erase what the attacker's hands had left behind. The forensics team still collected everything they could: soil samples, fabric fragments, biological samples on and around the victim's body, sealed them, and sent them to the lab, even though they knew that an outdoor street scene at the end of March was not the kind of scene that was generous to investigators. Rachael's body was taken to the medical examiner's facility for a full autopsy, and it was there, under the cold white lights of the examination room, that technicians obtained what would later become the most important piece in the entire case, even though at the time no one recognized its true value: an unidentified DNA sample from the victim's body. It was the biological signature of the attacker. But at that time, in 1991, the CODIS system, the FBI's national DNA database that allows matching biological samples with criminal records nationwide, did not exist until 1998, 7 years after Rachael was murdered. Criminal DNA analysis at that time could only confirm who a sample belonged to if there was already a specific suspect to compare it with. Akron police held in their hands the biological signature of Rachael Johnson's killer, but they had no database to look up whose signature it was. This was the paradox the case would carry for nearly the next 30 years. The scene had everything: the body, signs of the attack, the killer's DNA, but was missing exactly one thing: the technology to turn all that evidence into a name. In the days that followed, based on the location of the disabled car in the parking lot near the intersection of Dan Street and Glenwood Avenue, and the location of the body found in the 700 block of Weller Avenue, the Akron Police Department launched an expanded canvassing operation to determine the route Rachael might have taken in the time between when she left the car and when her body appeared in Chapel Hill. The distance between the 2 points was not too far, close enough for a person on foot to cover in a few minutes to a few dozen minutes depending on the route chosen, but also far enough that between those 2 points there were many turns, many side roads, many empty lots, and poorly lit areas that at night could become anything: a shortcut, a temporary hiding spot, or a place where no one would hear a cry for help. The search teams were divided into small groups and swept along the roads connecting Dan Street and Weller Avenue, including both the main roads a normal pedestrian would choose and the side paths, back alleys, closed nighttime commercial parking lots, and scattered vacant lots between the residential areas. They looked for anything that might be relevant: personal items belonging to the victim, torn or dropped pieces of clothing, sharp tools, bottles, traces of blood on sidewalks or fences, anything that stood out from the normal landscape of a residential neighborhood on an early spring morning. Every tree root, every roadside bush, every hidden corner behind low-rise buildings was checked with the naked eye and recorded manually, because in 1991 there were no drones, no common handheld infrared cameras, and no GIS systems to build prioritized search maps. Everything depended on feet on the ground, eyes, and the experience of those walking the pavement. In parallel with the route canvassing, investigators also examined the area around the disabled car to determine whether there were signs that the attack had occurred right there or at another location before the body was taken to Weller Avenue, the parking lot, the sidewalks along Dan Street, and the entrances to nearby homes at the Glenwood Avenue intersection. All were within the inspection area, but the road surface was dry. The late March weather did not leave enough moisture to preserve shoe prints or drag marks, and daylight did not help much when any traces on the asphalt had already had an entire long night to be erased by wind, vehicles, and the natural movement of the neighborhood. Throughout the entire expanded canvassing process, no findings were clear enough to build a specific investigative direction. Publicly available documents about the case do not record any significant physical evidence collected other than the DNA sample from the autopsy. No murder weapon was found, no personal items of the victim were found along the route, no fabric samples or blood trails that could trace a possible path of movement. This does not necessarily mean the area was completely free of traces, but it may reflect the double limitation of both collection technology and outdoor crime scene conditions in 1991, when even a small piece of fabric or a faint blood smear on the sidewalk could have disappeared before the search team arrived. The overall results from the field canvassing brought the investigators right back to the position they had stood in before. The DNA sample collected from Rachel's body was the only piece of evidence with the potential to lead to the killer, but that potential was locked behind a barrier that no field effort could overcome: the limitation of large-scale DNA matching technology. While the field canvassing results brought no new leads, the Akron Police Department shifted its focus to interviewing people who had direct connections with Rachael Johnson in order to determine whether anyone in the victim's circle could provide information leading to the killer or might themselves be a person of interest. The process began with the friend who was with Rachael that night, the last person to see her alive. This person recounted the events of the evening. The two went out in the friend's car. On the way back, the car got a flat tire in the parking lot near Dan Street and Glenwood Avenue. Rachael got out and walked to find help, and she never returned. This statement was consistent with the confirmed location of the car and contained no clear internal contradictions, but it also provided no additional details about the direction Rachael went, whether she met anyone along the way, or whether any cars or figures appeared in the area at that time. The friend said they waited in the car and did not see Rachael return, but the darkness and distance severely limited visibility, and after an unclear period of waiting, this person sought help from others to deal with the car, without knowing that Rachael had never reached the place where she intended to find assistance. Next, investigators worked with Rachel's immediate family, her father, Larry Johnson Sr., and stepmother June Johnson. Both confirmed that Rachael had no conflicts with anyone recently, had not mentioned being followed or threatened, and had no serious financial or emotional issues that could lead to violent conflict. Her life revolved around work and her daughter Catelyn, with no signs that she was involved in any dangerous relationships. The family was cleared from the list of suspects based on consistent statements and the absence of any factors indicating involvement in the night of March 29. In addition to family and close friends, police expanded interviews to people in the area: neighbors, co-workers, those who regularly interacted with Rachael or her family. No one provided conflicting information, no one remembered seeing anything unusual on the night of the incident, and no one offered a name worth the investigators stopping to ask further questions. All interviews ended in the same place: emptiness. And that was the most notable thing about the entire interviewing phase. Because in Rachel's circle there was one name that should have appeared somewhere in the file but did not exist on any page: Daniel Rees. Rees, 28 years old at the time of the crime, lived near Rachel's family area and was known to have been around the place where she was last seen. He was not a complete stranger. He knew the victim's family, lived right in the neighborhood, the kind of person that any neighborhood canvass should have reached, but he never appeared in the file. No witness mentioned his name, no connection between him and Rachael was brought up by anyone, and no detail in any interviewed person's statement led investigators to his door. He was right within the search radius, right in the list of people police could have knocked on doors for, but he slipped through every net that the 1991 investigative process could cast. Many years later, when the case was solved and people looked back at the entire file from the beginning, Detective James Paschilich would describe Rees with words that carried both acknowledgement and helplessness. He was a ghost in the investigation. He wasn't anywhere in the file. And then one more sentence, even heavier: he was like a chameleon. No one, including us, had any clue that he was the perpetrator. The analysis of all the data collected in the first few weeks, From the crime scene on Weller Avenue, the field canvas around Dan Street and Glenwood Avenue, witness statements, interviews with those involved, to the DNA sample sitting silently in the evidence locker, did not yield any specific leads to narrow down the pool of suspects, causing Rachael Johnson's case to gradually slip into a state that any investigator understands but no one wants to admit: complete deadlock. Not because of a lack of effort, not because of procedural errors, but because the entire structure of the case revolved around a paradox that could not be solved with the tools of 1991. There was biological evidence of the killer, but no way to know who that evidence belonged to. There was a clear scene of violence, but no direct witnesses. There was a body, but no line of inquiry that led to a specific name. Weeks passed without new information, then months, then quarters, and the gap between the day the crime occurred and the present kept widening without bringing any data to fill the gaps in the file. The investigators initially assigned to the case gradually had to move on to new files, other cases waiting to be handled in a city where violent crime did not stop to wait for an old case to be solved. Rachael Johnson's file was not closed. According to procedure, an unsolved homicide is never officially closed, but it shifted into a state that within the police department was understood as technically open, frozen in reality, meaning the file still existed in the system, the evidence was still preserved, but no active investigative activity was being conducted, and there was no reason to launch any new steps when everything that could be done had already been done. But amid that long silence, a purely technical decision was made during this period that at the time no one considered noteworthy. No one wrote a special report about it. No one saw it as a turning point. But nearly 30 years later, it would become the most important decision in the entire history of the case. The DNA sample collected from Rachael's body was preserved in its original state in the Akron Police Department's evidence locker according to long-term biological storage standards with temperature and humidity controls and coded classification to ensure the sample did not degrade in quality over time. From 1992 onward, the life of Rachael Johnson's family entered a form of existence that those who have never lost a loved one to violence would find hard to imagine. Not grief that gradually fades over time, as when losing a loved one to illness or old age, but a kind of waiting with no destination where the pain does not diminish because no answers are provided to close it. Katlyn Puzakulix, Rachael's daughter, 3 years old when her mother was murdered, grew up in the arms of her family but without a single memory of the woman who gave birth to her. She did not remember her mother's voice, did not remember her mother's smiling face, did not remember the feeling of being held by her mother, or the scent of her mother's clothes when she hugged her. Everything she knew about Rachael Johnson came from what others told her, from old photographs, from the stories that her grandparents and relatives repeated over the years in an attempt to fill the void that the absence of a mother left in a child's life. But stories did not replace memories, and old photos did not replace presence, and no matter how hard the family tried, that void was still there, clear and impossible to fill, every day, every year, every birthday, and every time someone asked Katlyn about her mother. Larry Johnson Sr., Rachael's father, and stepmother June Johnson lived with that pain in the way of their generation, not by talking a lot, but by continuing to move forward day by day while carrying a burden on their backs that never got any lighter. They cared for Katlyn, trying to fill the role that Rachael should have played, and waited for a call from the police, waited for a name, waited for someone to come and say they had found the person who did that to their daughter. That call did not come in the first year, did not come in the 5th year, did not come in the 10th year, and still did not come when more than 20 years had passed. In 2013, in an interview when the case was included in a review program, June Johnson spoke with the voice of someone who had grown so accustomed to living with the void that it had become part of the structure of every day. Life is not easy, and no matter what you do, that void is always there. Then she added, as if looking back on the entire 2 decades in a single sentence, "We never thought that after 23 years we would still be wondering." Also in 2013, Ohio Attorney General Mike DeWine officially added Rachael Johnson's case to the Ohio Unsolved Homicides Initiative, a statewide database compiling approximately 1,102 unsolved homicides across Ohio, aimed at systematizing information, calling on the community to provide tips, and creating channels for anyone with information to submit it through the Attorney General's website, the Akron Police Department's website, or by calling the hotline at 330-375-2552. Rachael's file was posted publicly along with photos and a description of the case, in the hope that after more than 2 decades, someone somewhere might remember a detail they previously thought was unimportant, or a confession that someone had once heard but never reported. But the weeks passed after the program was announced, and there were no valuable responses. No calls provided the name of a new suspect, no witnesses came forward after more than 20 years of silence, and no confessions came from anyone. Rachael's case sat among more than 1,000 similar files, each file representing another family also waiting, also living with a void, and public attention, which was already thin when spread across more than 1,000 cases, was not enough to create any change for Rachael's case specifically. But perhaps the most frightening detail in the entire period stretching from 1992 to the late 2000s was not in the police files or the Unsolved Homicides program, but right on the street that Rachael's family still walked down every day. Because throughout the years that Larry Johnson waited for a call from the police, throughout the years that June Johnson tried to fill the void for Catlin, throughout the years that Catlin grew up without her mother and only knew her through stories, the man who killed Rachael lived directly across the street from them. Daniel Rees did not flee after that night, did not leave the city, did not cut ties with the area where the crime occurred. He stayed right there, one street away from the victim's family, and did what he would later call the worst thing of everything he had done. He stepped into their lives. He gave Catlin, the 3-year-old child whose mother he had taken away, her first motorcycle ride in her life. He attended family birthday parties. He worked with Rachael's sister for many years and became her favorite co-worker because he regularly bought her lunch. He was there, right in front of everyone, while the family and police searched everywhere for the killer but did not know that he was sitting at the dinner table with them. Catlin met Rees for the last time around 2007, more than 16 years after he killed her mother, and up until that point she had never, not even once, suspected that the man living across the street from her, the man who had given her rides and attended her family's birthday parties, was the person who had put an end to her mother's life on that dark night in March 30 years earlier. In 2018, an arrest in Sacramento, California shook the entire U.S. criminal justice system and permanently changed the way law enforcement agencies across the country viewed cold cases sitting silently in storage. Joseph DeAngelo, 72 years old, a former police officer, was arrested and charged as the Golden State Killer, the man responsible for a series of rapes and murders in California in the 1970s and 1980s, one of the longest-sought serial killers in American history. What made the arrest shocking was not only the perpetrator's identity, but the method used to find him. Forensic genetic genealogy, a technique completely different from anything criminal investigations had used before. Instead of directly matching a suspect's DNA sample in CODIS, a system that only contained profiles of people who had been arrested or convicted, this method used public genealogy databases where millions of Americans voluntarily submitted DNA samples to learn about their ancestral origins and connect with distant relatives. When a crime scene DNA sample was uploaded to a genealogy database, it did not need to find the exact suspect. It only needed to find a person with a genetic relationship, even a third or fourth cousin, and from that connection point, investigators built a reverse family tree, tracing family branches, gradually eliminating individuals until the pool narrowed down to a single person who matched all the criteria: age, gender, geographic location, and connection to the area where the crime occurred. After the Golden State Killer case, hundreds of police agencies across the United States began looking back at their evidence lockers with completely different eyes. DNA samples that had once been considered useless because they did not match anyone in CODIS suddenly became potential keys as long as they were still preserved well enough for analysis. And in Akron, Ohio, in the Akron Police Department's evidence locker, the DNA sample collected from Rachael Johnson's body on March 30, 1991, was still there, intact, nearly 28 years old. In 2019, the Akron Police Department partnered with the Ohio Bureau of Criminal Investigation and the Texas-based genetic analysis company AdvanceDNA to submit the DNA sample from Rachael Johnson's case into the genetic genealogy process. This was a biological sample that had been collected and sealed in 1991, that had survived nearly 3 decades in storage, through file transfers, through periodic reviews, through the years when no one touched it because there was no reason and no tools to do so. And now, for the first time since it was collected, it was taken out of storage with a purpose that no one in 1991 could have imagined, not to match it with a known suspect, but to search for relatives of the killer in a database where the people who submitted samples had never thought their DNA would help solve a murder case. AdvanceDNA uploaded the DNA profile to the genealogy database and began the process of searching for partial matches, not full matches, because that would mean the killer himself had submitted a sample, but matches at the level of relatives enough to determine that the owner of the DNA sample in the database had a genetic relationship with the person who left the sample on Rachel's body. When the results came back positive, one or more individuals in the database were identified as having a genetic link to the killer. The analysis team began the process of building a reverse family tree, a process that required combining genetic analysis, civil records, vital records, and public data to redraw family branches, determine who gave birth to whom, who was siblings with whom, and slowly narrow the pool from dozens, even hundreds of people in the same family line down to a small group of individuals who matched the crime profile. Males, the right age in 1991, with geographic ties to the Akron area. And from that small group, one name stood out more clearly than all the rest. Daniel Lee Rees, 57 years old in 2020, living in Barberton, Ohio, not far from Akron, 28 years old at the time Rachel was murdered, who had once lived near the victim's family area, and who had no criminal record in the justice system, precisely the reason he had never appeared in CODIS or any other criminal databases that Akron police had access to throughout the past 30 years. To confirm that the genetic genealogy results were not an error or a coincidence, police needed to obtain a direct DNA sample from Rees to match against the original 1991 sample. But requiring a person who had not yet been charged to provide a DNA sample required a court order or voluntary consent, and any direct approach to Rees carried the risk of alerting him and causing him to destroy evidence or flee. Instead, investigators used a method that had been established in the U.S. legal system, collecting DNA from the trash that Rees placed out on the curb for collection. According to case law, when an individual puts trash on the sidewalk or in a public place for pickup, that person has abandoned any privacy interest in its contents, and police have the right to collect anything from it without a search warrant. The DNA sample extracted from Rees's trash was sent to the laboratory, and when the results came back, they confirmed what the genetic genealogy had indicated, an exact match with the DNA sample collected from Rachael Johnson's body on March 30, 1991. After 29 years, the sealed letter in the evidence locker had finally been read, and it contained only one name. Detective James Poshilish, who had followed the case file, called the genetic genealogy results the key to everything and stated that this was a wonderful tool for solving old, difficult cases that might never have been solved without this technology. And when looking back at the entire 29 years that Rees had lived freely in the community, right next to the family of the woman he had killed, the question was not why the police had not found him sooner, but how they could have found him when every available tool throughout nearly 3 decades had no ability to reach him. Rees had no criminal record. His DNA did not exist in any criminal database. He had never appeared in the initial investigation file. No witness mentioned his name. No lead led to his door. He lived directly across from the victim's family, rode with them, ate with them, played with the daughter of the woman he killed, and not a single person, not even the most experienced investigators in the Akron Police Department, had any idea. On March 11, 2020, nearly 29 years after the night Rachael Johnson stepped out of her flat-tired car and walked into the darkness on the road near Dan Street, Daniel Lee Rees, 57 years old, was arrested at his residence in Barberton, Ohio, and charged with aggravated murder in the death of Rachael in March 1991. He was taken to the Summit County Jail and awaited appearance before the grand jury, ending nearly 3 decades in which he had lived as an ordinary person in the community, unsuspected by anyone, untouched by any system, and absent from any criminal file or suspect list of any agency in the entire United States. News of the arrest spread quickly in the Akron and Tallmadge communities, and the first reaction from most people who knew Rees was not confirmation. No one said, "I suspected him all along," or "I always felt something was off," but pure shock. The kind of shock that comes from realizing that a person you had known, had met, had trusted for many years, had been carrying a secret you could not imagine even in the worst scenario. But no one was more shocked than Katlyn Puzakulix, Rachel's daughter, 31 years old at the time of Rees's arrest, the woman who had lived her entire life without her mother, without a single memory of her mother, only knowing her through old photos and stories from her grandparents, and now standing before the information that the man who had taken her mother away was the very person she had once seen as a friendly neighbor, the person who had been present in countless moments of her childhood, the person she had never had any reason to fear or suspect even once in 30 years. Catlin told reporters, and her voice carried something that no words could describe accurately except shock that had crossed the boundary of ordinary shock. "It's crazy, it's really crazy that this guy lived right across the street and had the nerve to insert himself into our lives." Then she added, each detail like a memory whose meaning had been completely reversed in a few seconds. "He gave me my first motorcycle ride. He lived right across the street. He was always around. I never suspected him of being anything but harmless." Every memory Catlin had with Rees, the times he stopped by the house, the times he laughed and talked with the family, the sound of the motorcycle engine when he rode her through the streets of Akron, was now stained with a different, darker, colder layer of meaning that could not be removed. She had countless memories with Daniel Rees, but she had no memories at all of Rachael Johnson, her mother, and the person who had created that unfair distribution. The person who had taken her mother away and then placed himself into that void was the same person. When details about the relationship between Rees and the victim's family were made more public, the picture became clearer and even more terrifying. Rees did not just happen to live nearby and occasionally cross paths. He actively inserted himself into Rachel's family life in a systematic way that lasted for years. He attended family birthday parties. He worked with Rachel's sister for many years, and during that time, he became the person she called her favorite coworker, partly because he regularly bought her lunch, partly because he always appeared friendly and easygoing, the kind of behavior that on the surface looked like ordinary kindness, but when placed in the context that he was the man who had killed her older sister, became something for which ordinary language had no accurate words. Why Rees did this, why he did not simply disappear from the lives of Rachel's family, but instead chose to stay, to approach them, and to build relationships with the very people he had caused the greatest harm to, is a question that the case file does not provide a clear answer to. At the trial later, Rees would apologize to the Johnson family not only for the murder, but also for befriending them for many years afterward, calling it the worst thing of everything he had done, a remark that showed even he recognized that sitting at the dinner table with the family of the woman he killed was a different kind of cruelty, slower, quieter, but far more prolonged than the violence on that March night in 1991. But the specific motive for this approach, whether it was to monitor the progress of the investigation, to control the situation, to satisfy some psychological need, or simply because he lived nearby and the contact happened naturally and gradually became a habit, was never disclosed in any public documents about the case, and may never be known beyond what Rees kept in his own mind. After being arrested in March 2020, Daniel Rees was held at the Summit County Jail while awaiting review of the case file by the grand jury and a decision on formal charges. The legal process from the time of arrest until the final sentencing lasted more than 3 years, a period that, for Rachael Johnson's family, after nearly 3 decades of waiting, saw every passing month carry the same question: whether the justice system would truly bring this man to where he belonged, or whether there would be yet another reason for everything to slip through their fingers once again. Defense attorney Joe Gorman, representing Rees, did not deny the existence of the evidence but focused on challenging the validity of the 2 most important pillars in the prosecution's file: the statement Rees had given to investigators after his arrest and the DNA sample obtained from his household trash, a method that the defense could argue violated privacy rights or failed to maintain a proper chain of custody. If the court ruled that either of these pieces of evidence was inadmissible, the entire case would be severely weakened. The DNA from the trash was the only bridge between the genetic genealogy results and confirmation of the perpetrator's identity, while the statement was the only element showing that Rees had admitted any involvement. However, after review, the court ruled that both pieces of evidence were valid and admissible at trial, a decision that closed the defense's most important avenue of challenge and placed Gorman before a clear reality. If the case went to a jury trial with the full chain of DNA evidence presented, the likelihood of Rees being convicted was very high, and the possible sentence could be the death penalty under Ohio law at the time the crime occurred. From that point, plea negotiations began between the defense and the prosecution. The final agreement reached was as follows. Rees agreed to plead guilty to aggravated murder, a particularly serious charge under Ohio law, and to waive his right to a jury trial. In exchange, the prosecutors agreed to change the underlying charge from rape to kidnapping, a technical adjustment but one with decisive legal significance because it eliminated the possibility of a death sentence. Gorman explained his client's decision with two reasons. Rees is not the same person he was 30 years ago, and he did not want the victim's family to have to go through a lengthy trial with all the details that would be revealed in court. Gorman also acknowledged what anyone looking at the numbers could clearly see. This is essentially a life sentence. He understood that when he walked in here, the sentencing hearing took place on July 28, 2023, at the Summit County Court, before Judge Susan Baker Ross, more than 32 years after the night Rachael Johnson was murdered on the streets of Akron, and more than 3 years after the day Daniel Rees was arrested. This was not a contested trial. There was no jury, no presentation of evidence, no back and forth between prosecution and defense, but rather a sentencing hearing after the defendant had pleaded guilty, and according to legal procedure, the victim's family had the right to make statements in court before the judge imposed the sentence. The courtroom that day did not need complex legal arguments to create weight. The weight came from the people who had waited more than 32 years to stand just a few meters away from the man who had killed their loved one and to say what they had carried in their hearts all that time. Larry Johnson Sr., Rachel's father, spoke first, and as soon as he stepped up to the podium, the restraint he had maintained for more than 3 decades broke in front of the entire courtroom.